Hi everyone, and welcome back to this lecture series where we discuss equity and trust law for the University of London exam. Now, in our first session, we talked about an introduction to equity and trust law, and we talked about the different types of trust that exist. Today and over the next few weeks, we're going to discuss how you create a valid express trust. Let's get started. Now, as a quick reminder, express trusts are trusts which are created intentionally by the set law for the benefit of the beneficiary. So if you remember our standard template, a set law is the person creating the trust. He gives property to the trustee, the person who is going to hold the property for the benefit of the beneficiary. An express trust is a trust which is intentionally created by the set law. So in order to create an express trust, you need to satisfy substance, formalities, and constitution. In today's episode, we're going to focus on substance. This requirement of substance means that the set law must clearly indicate his intentions in creating the trust. That means the parameters of the trust must be very clearly indicated by the set law when he creates the trust. These are that his intention to create the trust, who the beneficiaries of that trust, and who the subject matter of that trust are. This is very clearly provided for in a case called Knight versus Knight, which recognizes these three requirements that substance needs to satisfy as the three certainties. So there are three certainties that you need to satisfy when creating and satisfying the requirement of substance. Number one, certainty of intention. Number two, certainty of subject matter. And number three, certainty of objects. So if you want to create a valid trust, you need to satisfy three requirements: substance, formalities, and constitution. And under the requirement of substance, you need to ensure that the three certainties are satisfied. That is, there must be certainty of intention, certainty of subject matter, and certainty of objects. Certainty of intention simply means that the set law must have a very clear intention to create the trust, and that intention must be very clearly expressed when creating the trust. That means he can't use confusing and ambiguous terms when expressing his intention to create the trust. In law, we call these precatory words. You can't use precatory words when creating a trust. Now, for example, in the case of Re Adams and Kensington Vestry, the set law tried to create a trust using the words "in full confidence that she will do what is right." Court said that that was not sufficient to satisfy this requirement of certainty of intention. So the intention must be very clear and unambiguous. So using words like "in full confidence," "my wish," "my desire," "my hope" will not be sufficient to create a valid intention to create a trust. Imagine I want to create a trust where I leave some property to you. I give this property to the trustee and say, "It is my wish that this property be given to you." Now the trustee has gotten this property and has to decide whether to give that property to you or not. Unfortunately, the words that I have used is not clear as to whether the trustee has to give it to you or whether it is simply up to their discretion, because the words I have used are ambiguous. So you can use cases like Re Adams and Kensington Vestry and even Re Diggles, where the words "my desire" was used, as examples of the court saying that this is not sufficient to satisfy this requirement of certainty of intention. You need to use clear words, like saying, "I give you this property to hold on trust for X." That is very clear. The intention is very clearly expressed when I say that I want you to hold this for X. There is no ambiguity in the words that I use. Now, an interesting set of facts arose in the case of Comiskey versus Bowring-Hanbury. In this case, the set law tried to create a trust using the words "in full confidence." But in addition to these ambiguous terms, the set law had a default clause. He said, "in default to my nieces in equal shares." Now, the courts in this instance said that the ambiguous terms did not give rise to a trust because the use of the words "full confidence" didn't inspire enough intention for the courts to say that this was a valid trust. But the courts relied on the default terms that Comiskey had used and said that there was an intention to create a trust based on those default terms. So even if you try to create a trust using ambiguous and unclear terms, you can cure that defect by having a default term of clear terms. Now, all these cases that we've talked about are three-party cases where a set law tries to give property to a trustee to hold for a beneficiary. Now, there's another type of trust that can arise. That is where the set law becomes the trustee themselves, holding it for the beneficiary. We call this type of trust a self-declaration of a trust. This is where the settlor themselves become the trustee. Now, the way intention works in this kind of self-declared trust is different to the way that intention works in a three-party trust. Now, in the case of a trust which has three parties, where the settlor and the trustee are two different people, the intention must be clearly indicated using the words by the settlor. But when the settlor and the trustee are the same person, using clear words is a little absurd. Imagine if I decide to hold my phone on trust for you. I am the owner of the phone, so I am the settlor, and I am holding it for you now, and therefore I am the trustee, and you are the beneficiary. Now, there is no point in me using clear words to say that I am going to hold this for you, because I already know my intention. Instead, the courts say I must show my intention using clear actions. So this happened in the case of Jones versus Locke. In Jones versus Locke, a father held out a check to a baby and said, "Baby, I'm holding this check for you." He did nothing other than say those words. So when the child became older, the child asked for this money from the father. The court said, no, there is no valid trust. Why? Because the father's actions did not give rise to a clear intention. The words itself were insufficient to give rise to a trust. Now, on the contrary, if the father had taken an action like depositing that check in a separate bank account, keeping that money separate, those actions show that the father's intention to create the trust was a serious one. The fact that he hadn't done that meant there was no valid trust. A good example of this kind of self-declarations of trust is the case of Paul versus Constance. In this case, a man and a woman cohabited together. Now, the man would often say that the money in his account was hers as much as it is his, suggesting that he was holding this money for her. Now, the words itself obviously would not be sufficient to give rise to a trust. But the courts found that his actions also showed that he was holding this money for her. What were these actions? He allowed her to make deposits into that account. Their joint bingo winnings went into that account. And she was allowed to make withdrawals from that account. Those actions combined with the words that he used showed that he was very clearly holding this property for the wife as well. So finally, what are the consequences of not satisfying certainty of intention? If there is no certainty of intention, the courts will say that there is no valid trust. So the subject matter that has been transferred to the trustee can be kept by the trustee as a gift given to the trustee. For example, if I give you some property and I tell you to hold it for X, then you have no choice but to hold it for X. But if I give you some property and say it is my wish that you give this to X, it suggests to you that you have a choice. You can keep this property or give it to X. It is at your discretion. So therefore, the courts say, in the absence of certainty of intention, the trustee can keep the property absolutely. This is actually one of the very rare instances where the courts say that the purported trustee can keep the property absolutely. Next, let's talk about certainty of subject matter. This simply means that the subject matter of the trust must be very clearly indicated when creating the trust. Let's say, for example, you use ambiguous words when you try to create a trust. You say to X to hold a bulk of the property for Y. Now, X doesn't know what a bulk of the property is. A bulk is an ambiguous term. So therefore, the courts will say there is no valid certainty of subject matter, and therefore the trust fails. This is exactly what happened in the case of Palmer versus Simmons. In Palmer versus Simmons, the set law created a trust saying for the trustee to hold a bulk of the property for the beneficiary. Court said there was no valid trust. Now, this case of Palmer versus Simmons can be directly compared to Re Golle's will trust. In this case, the set law tried to create a trust where he asked the trustee to pay a reasonable income to the beneficiary. Now, just like the word bulk, reasonable income is also ambiguous. So it was not certain as to what the subject matter of this trust was. So the courts in this instance interfered and said, look, we can tell you how much a reasonable income is. And they cured that defect and therefore satisfied this requirement of certainty of subject matter. So then the question arises, why didn't they interfere in Palmer versus Simmons and clarify what a bulk is? The problem is that the word bulk, there is no measuring stick for the courts to use to define what a bulk is. But reasonable income can be calculated by the courts by using other metrics available in society. So the courts felt confident enough to say that we can cure the defect in Re Golle's but not in Palmer versus Simmons. Another instance where subject matter can be unclear is when the set law asks the trustee to hold a part of the property for the beneficiary. Now imagine the set law gives the trustee a property and asks him to hold a portion of that property for the beneficiary. The question arises, what portion? Because depending on what part of the property, the value of the property might change. Different parts of each property can have different values. Say for example, this is a land. Now, if I ask this trustee to give 1/4 of this land on trust, the question arises, which 1/4? Because if there is let's say a highway going on this side, the value of this part and this part might be higher than the other two. So therefore, if this trustee holds part A or part B for the beneficiary, then the beneficiary gains more value. But if he gives part C or part D, then the beneficiary gets less value. So there is ambiguity as to what part of the property has to be held on trust. If we tell the trustee, look, give 1/4 of this property for the beneficiary, we have to specify which 1/4. Part A, part B, part C, or part D. Failing to do so will result in the trust failing. The reason for this is because each part of the property can have different values. This was very clearly discussed in the case of Real London Wine Company. In this case, the wine dealer wanted to give some wine cartons or wine boxes to a customer. So he said for a certain number, let's say 5 boxes of wine in his cellar to be given to the customer. But the question remained, which 5 boxes? Because depending on which 5 boxes, the value of the property received by the customer would drastically change. So it needed to be very clearly indicated and segregated as to which 5 cartons or which 5 boxes needed to be given to the customer. The fact that the wine dealer did not do that meant the trust failed because there was no valid subject matter clearly defined. So in the event of tangible property, it's very clear that each part of the property can have different values. Even in identical property, there can be small differences. Imagine mass-produced things like books. Even in a book, a physical book, there can be small differences in printing, in quality that may exist from one part to the other. So when you are asking physical property to be given on trust and a part of that physical property to be given on trust, you need to specifically say which part. You have to segregate. But does the same logic apply when you are dealing with intangible property? Property that is not tangible, that is not physical. Now, in such an event, arguably, each part of the property does not have differing values. Say, for example, shares. It doesn't matter if you allocate shares 1 to 100 or 900 to 1000. All of these shares have the same value. So therefore, arguably, you don't need to segregate when you leave a part of intangible property on trust. This was exactly what was discussed in the case of Hunter versus Moss. In this case, the settlor wanted to give 50 out of his 950 shares on trust. The courts held that it did not matter which 50 of these shares were held on trust. Therefore, the fact that the settlor had not segregated did not affect the validity of the trust, and the trust was valid nonetheless. So the case law seems to suggest that in Re London Wine Company it was held, if it's tangible property, you need to segregate the part of the property that becomes part of the trust. And in intangible property, you don't need to segregate, thanks to the case of Hunter versus Moss. However, writers like Penner have disagreed with this opinion. Penner is one of the key writers we meet in the study of equity and trust law, and Penner says that even in intangible property, there can be minor differences in parts of the property. Say, for example, certain shares might be encumbered by certain other values which other shares might not be. Say, for example, if I have promised 100 shares to another person, then those 100 shares come with an added weight that the other 850 doesn't. So it's important for the settlor to separate even in the case of intangible property. Now, in the absence of doing so, the only way to make sense of the case of Hunter versus Moss is to decide that there would be a trust for all 950 shares. Let me explain. So, in this case, the settlor wanted to create a trust for 50 out of his 950 shares. Now, obviously, the court said that you don't need to segregate it. Penner says what in reality will happen in such an instance is that the trustee will hold all 950 shares on trust. 50 out of that 950 will be held for the beneficiary, and 900 out of that 900, the remaining shares, will be held back for the settlor. And until the settlor segregates the 50 that is to be held for the beneficiary, the settlor is suspended from using his own 900 shares. So according to Penner, this would be a constructive trust that is being imposed by the courts to solve this issue of not segregating the 50 shares that were to be part of the property. And finally, issues of certainty of subject matter can arise when the beneficial interest becomes unascertainable. Now, let's talk about this in the context of a case, Boyce versus Boyce. In this, a father wanted to create a trust in favor of his children, the two daughters. So what did he do? He left his three properties, we call them Greenacre, Whiteacre and Blackacre. These three properties, he gave it to his wife and asked her to hold it for the two children. And he told that wife that the first daughter, the oldest daughter, was to pick the property that she wanted out of Greenacre, Whiteacre and Blackacre, and the youngest daughter was to get the remaining two. Now, this is clearly a valid trust where all the parameters have been satisfied. But unfortunately, the eldest daughter died before she could make her choice. When that happened, it became unclear as to which two properties would go to the youngest daughter. The beneficial interest becomes unascertainable. In such an instance, the courts will hold that the trust fails because the certainty of subject matter is not satisfied. So finally, what happens when there is uncertainty of subject matter? When there is uncertainty of subject matter, the trust fails and the trustee will have to return the property back to the settlor. So unlike in the certainty of intention issue, when the trust fails, the beneficiary cannot keep the property for himself. He has to return the property back to the settlor on what we refer to as a resulting trust. So this goes back to the principle we talked about last week, which is that the trustee cannot benefit from the trust. It would be unjust enrichment for a trustee to benefit from the trust. So when the trust fails because the subject matter is unclear for whatever reason, the trustee will have to give the property back to the settlor. The final requirement of the three certainties that we need to satisfy is the certainty of objects. Certainty of objects means the beneficiaries of the trust must be very clearly identified. Say, for example, I am creating a trust where I want to give Blackacre to the trustee to hold for a beneficiary, I have to identify this beneficiary by name very clearly. If I use a very clear name and identify the beneficiary by his name, then the trust is valid. But if I use generic terms in identifying this beneficiary, then the trust is not valid. Let's say, for example, I give 100,000 to you and I tell you to hold it for my relatives. The trust would not be valid because I have used generic terms. It is unclear as to who these beneficiaries are going to be, who the beneficiaries of the trust are. Now, a trust doesn't always fail just because you use a generic term. It depends on whether you can satisfy the threshold test that has been set to see whether the beneficiaries are clear or not. So this depends on different types of trusts. Depending on fixed trust or discretionary trust, the test that we apply will change. So if you can't remember, a fixed trust is a trust where the terms of the trust are very clearly identified by the settlor when creating the trust. So the trustee has a minimal amount of work to do when executing this trust. He does not need to use his discretion at all. He just has to implement what the settlor has said. A discretionary trustee, on the other hand, is where I tell the trustee to use his discretion in distributing the property. So the trustee has some kind of discretion that he can use. So the test we use to see whether certainty of objects is satisfied depends on what type of trust you're dealing with. If it's a fixed trust, the test is a complete list test. Let's take this example. I want to give £1,000 to my children equally. So the beneficiaries in this instance would be my children. And how is it supposed to be distributed? It's to be distributed equally amongst my children. So the trustees very clearly know exactly how they are to execute it. They have no need to use their discretion. Now, the only problem here is the word that I have used, children, is a generic term. I haven't recognized my children by name. So as a result, there is a problem of certainty of objects. To cure this, we use the complete list test. According to the complete list, the trustee must see if he can make a complete list of all the beneficiaries to this trust. So in the event of my children, let's say I have 2 children. If the trustee can make a list of my 2 children, then he can then distribute the £1,000 amongst my children, 500 each. Let's say I have 3 children, then you split it exactly by 3. The trustee knows exactly how much to give each beneficiary depending on how many people are on the list. So that is why it's important to create a complete list, because in a fixed trust, the trustee has no discretion to give different amounts to different people. He has to give the same amount to every beneficiary. So the only way he can know how to distribute the property is to know how many beneficiaries and who those beneficiaries are. Now, in the case of discretionary trust, the test that we currently use is the is or is not test. We don't insist that the beneficiaries must be identified as a complete list, but we simply say that the trustee must know whether this particular person is or is not a person who falls within this generic class. Let's take an example. I want to distribute, let's say in this instance, 100,000 to my relatives. The beneficiaries are identified as a generic term, that is my relatives. Now the difference is that this is a discretionary trust. So the trustee can use his discretion when distributing this 100,000. He can decide how much each relative gets. So there is no need for him to create a complete list of my beneficiaries before he distributes it. If I had 20 beneficiaries, he doesn't have to divide this 100,000 by 20. That's not necessary. What he needs to know is whether person X is in fact is or is not a member of this class of relatives. If he can know that for certain, then he can distribute some portion of the funds to X. Let's say he can give £1,000 to X. Then when he finds Y, he asks the same question. Is he or is he not a member of the class? If he is not, he doesn't get any money. If he is, then he can give another sum, let's say 10,000 in this instance. Because the trustee can use his discretion, he can decide how much is distributed. He can give differing amounts to differing people depending on whether they simply satisfy this test, is or is not a member of the group. Now, when applying this is or is not test, two factors might become of significant concern. These are called conceptual and evidential uncertainty. This is not to say that this can't be a problem in the complete list test, but it's less of a problem in the complete list test. So the problems that you come across in the is or is not test is conceptual uncertainty and evidential uncertainty. Conceptual uncertainty is the wording that is used to identify this beneficiary, the generic term, is as a concept ambiguous. Think about it like this. If I use the words my friends when I am creating this trust, that the trustee is to distribute this amongst my friends as he thinks fit, then the word friend is conceptually uncertain. You don't know what a friend is because it varies from person to person. What the definition of a friend is very subjective. So there is no way for the trustee to know who exactly I considered a friend. So therefore there is conceptual uncertainty, and therefore it's very unlikely this trust can work. Now, on the other hand, evidential uncertainty is when evidentially it is not possible to determine whether a person falls into this category or not. Say for example, I leave some property for students of the University of London over 6 feet. Now, the problem might be that there is no way to know who these students who are over 6 feet tall are. Now, in that event, it is conceptually certain. There is no problem. We know exactly what the metric is to identify whether the person falls into this category or not. But the problem is there is no way to evidentially ascertain it. Therefore, the trust may suffer because there is evidential uncertainty. Now, how this conceptual and evidential uncertainty will impact the validity of a trust is a little complex and was discussed in the case of Rebadens. In Rebadens' deed trust, 3 judges had 3 different opinions on how these 2 factors may impact the validity of a trust. Now, in Rebadens, conceptual certainty and evidential certainty's importance was discussed by 3 judges. Justice Stamp said conceptual certainty and evidential certainty are necessary for a trust to be valid. Second judge said, Judge Sash said conceptual certainty is essential, but evidential certainty is not essential. And finally, Justice McGaw said the trust can be valid even if there is no conceptual certainty or evidential certainty, provided there is a reasonable group of people who will fall into that category despite these uncertainties. So it's very unclear as to how conceptual and evidential uncertainty will impact the validity of a trust where you have to apply the is or is not test. But a good metric seems to be that a majority of judges feel conceptual certainty is necessary. If conceptually the generic class that you have used is uncertain, then it's likely that your trust will fail. But if it's simply evidentially uncertain, then there is a chance that this can be cured and the trust can be valid. Now, the final thing you need to know about conceptual uncertainty is, can it be cured? Can conceptual uncertainty be cured? We seem to have different judges and different cases deciding this differently. In the case of Reed Tuck, it was decided that conceptual uncertainty can in fact be cured by delegation. That is, if you delegate to a person to cure this conceptual uncertainty, it is valid. Now, in this case, a trust was created in favor of a man, provided he married a woman of the Jewish faith. Lord Denning said this was conceptually uncertain. It is uncertain as to whether someone is of the Jewish faith or not. Now, in the trust, the settlor had put another clause, and that was that if there was any doubt as to whether the woman was of the Jewish faith or not, that were to be decided by the rabbi in London. Now that was held to cure this defect of conceptual uncertainty. The court said, yes, there was conceptual uncertainty here, and therefore the trust should fail because we can't satisfy the test, but this conceptual uncertainty can be cured by delegation to the rabbi. So Retuck says, yes, you can delegate and cure conceptual uncertainty. But the other cases that we have suggest that you cannot do that. Coxon, Teppers both say that you cannot cure conceptual uncertainty by delegation. In fact, Teppers goes so far as to say that Lord Denning in Retuck got it wrong. That in Retuck, what was at stake was not conceptual uncertainty but evidential uncertainty. It was not unclear whether a person was of the Jewish faith or not. It was simply evidentially impossible to know whether they were a follower of the Jewish faith or not. So it was an evidential issue, not a conceptual issue. So the courts seem to be split. Retuck says yes, conceptual uncertainty can be cured by delegation, whereas Teppers, Coxon says no, it cannot. Now finally, before we wrap up today's lesson, there's one more thing that we have to discuss. These two tests, the complete list test and the is or is not test, may be affected by something called administrative unworkability. This is when the trust is for such a large group of people that it is administratively impossible for the trustees to carry it out. So there is one famous case on this, R versus District Auditors, ex parte West Yorkshire Metropolitan CC, where the trust was created in favor of the inhabitants of the county of West Yorkshire. Now the inhabitants of the county of West Yorkshire was although it is a generic term, was conceptually certain and evidentially certain. There is very clearly, we know exactly as a concept what this group of people is, and number two, we know exactly how to evidentially identify them. But the problem was that this cohort included 2.5 million potential beneficiaries. The court said that the trustees cannot be expected to carry this out because of what they refer to as administrative unworkability. So if the burden placed on the trustees is too large, the courts might hold that the trust fails for administrative unworkability. Think about it. If I leave £100 and I tell you to distribute it amongst the inhabitants of a particular place, and that place has 1 million people, you would have to then distribute pennies or cents to each beneficiary of that county. Now that is not practical. That cannot be carried out because it is administratively unworkable. So that brings us to the end of today's lesson, where we discussed express trust and more specifically the requirement of substance under express trust. And this requirement of substance requires 3 certainties to be satisfied, which is intention, subject matter, and objects. Next week we'll talk about formalities. What are the formal requirements you need to satisfy in order to create an express trust? I'll see you in the next one. Take care.